Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
Welcome back into the Outlaw Lawyers. Josh Whitaker and Joe Hamer, managing partners, Whitaker and Hamer Law Firm, are your hosts, practicing attorneys here in North Carolina. Offices conveniently located: Raleigh, Garner, Clayton, Goldsboro, Fuquay Varina, Gastonia, and Morehead City. And Morehead City is where Cassandra Nicholas, an attorney with Whitaker and Hamer, also joining us remotely as we discuss a lot of different terms, legal documents that are out there you've got questions about, and we're kind of hitting those today. Interesting conversation. Go ahead, Josh.
You know, I want to go back to something we talked about the last segment. I got a new idea for a firm, a law firm of Whitaker and Hamer T-shirt. Right?
Give it to me.
Yeah.
Oh, I know where this is going.
I've seen some of the old ones.
Give it to me,
It's steaming, I think, right?
Yeah.
I think we should have a shirt where on the back we got to get a caricature. Is that how you say that?
Yes. Yep. You got it.
Of Joseph, like pulling something. I don't know what it would be, pulling something out of a pizza oven, and it's going to say, "Come get your piping hot fresh law." But I don't know what comes out of the pizza oven to represent law.
Some papers. A promissory note. How about that?
A personal guarantee.
Everybody loves. Yeah, with pepperoni
Legal
on
pie. Legal pie.
legal pie.
We'll have to put our best people to work on that.
Put our artistry team.
I'm on it.
Let's get a haiku
Cleared
on
my
that. How about
schedule.
that?
Yeah, Cassandra is going to, no court for you this week. You're just going to do that all week long. But, all right, so our show today is dedicated to defining legal terms, legal definitions that are pretty commonplace for us as lawyers who deal with it every day. But we find out in our consults that, other people who don't deal with it every day may not be super familiar with. And so in this segment, we want to talk about, fairly common terms we use in litigation, right? So when we're litigating an issue, settlement negotiations have failed, we have no choice left. And litigation should always, in my opinion, be a last resort. It's when everything else has failed. You're going to have to take your matter to a judge, a jury, and have a fact finder, have someone adjudicate it. And so litigation starts, not always, but almost always, litigation starts with a complaint. And so, Cassandra, tell us, what is a complaint?
A complaint is the initiation of a lawsuit, and it is listing out the complaints, the issues of one party against the other party, the defendant.
Right. So whether you're in, we talk about the difference a lot of times between, like when we're talking about a national issue, we talk about the difference between small claims, district court, superior court, federal district, federal civil, federal criminal. We talk about what court we're in because that determines a lot of things. That determines the rules we're playing by, what can be litigated. But in all those arenas, no matter what court you're in, the action's going to start with the plaintiff. The plaintiff is the person who has the complaint, who has the issue that needs to be adjudicated. They will file a complaint, and that's just a formal document that usually will recite the facts of how we got here. And it'll make their claims, right? So if their claims could be fraud, could be breach of contract, misrepresentation, there's a ton of claims that someone could make for an issue. And so they're going to list them all out. And then that complaint has to get served on the defendant or the defendants. Those are the people that are going to have to answer the complaint. So Joseph, what's the answer?
Yeah, so the complaint's the starting point, right? Like it may not be the starting point in the sense that you're usually going to try to negotiate something ahead of time, but it's the formal legal starting point. And like you said, it's going to contain the facts. It's going to contain the statement of whatever cause of action that there is, and the answer is going to essentially be a mirror image of the complaint from the defendant. So the defendant's presented with the complaint that's going to notify them of these factual things, these allegations, whatever it may be, and the answer is going to respond to each of those things, and it's going to make some representation as to like we said, what the response is. So the complaint gets the process started, and then if you're served with a complaint as the defendant, you're going to have to come and you're going to have to give some response to that complaint. And so what you may also do at that time is you may also make some counterclaims as well, or allege some things of yourself. But generally speaking, it is just the answer.
Yeah,
the answer to the complaint.
Yeah, so
that's why they call it The answer.
That's right.
Did you know that, Josh?
Clever.
Wasn't there a wrestler or a UFC guy? Wasn't there somebody whose nickname was the answer?
Allen Iverson.
I think Frankie Edgar, maybe. I'm going to Google that real quick.
Iverson?
I think Iverson's. I'll double check, but I thought he was the answer.
So yeah, the answer.
Yeah, AI was. I think AI was as well. The answer, Frankie Edgar. I got that first try, man. I didn't even Google it before I told you.
So the answer, that's what you do, right? So you're going to admit or deny the facts that were alleged in the plaintiff's complaint, and then you're going to, maybe you have counterclaims, maybe you don't, but you would assert those counterclaims, and then there's some defenses that you would need to assert if you were gonna use them, right? So you're going to answer by admitting or denying the facts. You're going to make your counterclaims, and you're going to make there's certain defenses that you have to give in your answer, or you've waived your right to use them. So complaint gets filed, you get served as the defendant, you answer. And so once that's done, we go into kind of discovery, which can be, it depends on the type of case, it depends on where it is, but discovery, I would say, is usually 6 months to 12 or 18 months, depending on the type of case and how quickly the parties get their discovery done. But discovery is a term that includes a lot of potential documents, and interrogatories is kind of the first one that people usually get served with. Interrogatories, let's say the plaintiff, you answer, you make some counterclaims, and the plaintiff will serve you with basically a list of questions. That's what interrogatories are, a list of questions that you will have to answer under oath, in theory, right? So you've got to answer them truthfully.
Under oath, in theory.
In theory, I guess there's no in theory there. I guess just under oath.
Yeah, you're going to be under oath. We're not going to do a theoretical oath.
And then you have request for admissions, right? That's a very powerful discovery tool. That's a document you can get served with, and if you don't answer those in a timely fashion, they can be deemed admitted, right? So you can lose a lot of your ability to argue facts if you don't respond to your interrogatories and your request for admissions. And either side can serve these discovery documents. This discovery process, the defendant can use it, the plaintiff can use it. So they're out there for everybody. The next level usually is a deposition, right? So once you've got your interrogatories answered, you got requests for admissions, admitted or denied, we can sit the defendant down and then ask them questions, and those are fun depositions.
You said discovery like 800 times, and all I can think of, man, and you're probably going to be too old for this. You remember the Discovery Zone? Is that a thing you remember?
Is that
Was it in Charlotte?
I remember
It was everywhere, man. It was. You remember it, Cassandra? Do you remember it?
Oh,
Yeah.
absolutely. They didn't actually have them in the Midwest, but I visit other places that
See,
did have
she's
them.
been around. You don't remember that?
not offhand?
I guess they started in '89, so you would have been 37 then. How old were you at that time?
In 1989, I probably had been in the 6th grade.
So you were a little too cool. It was like a place you went, man. And it was like a place you
the
went.
Chuck E. Cheese family without pizza.
Yeah, but wait, it was way cooler than Chuck E. Cheese. They had these big
Yeah.
things you climb on. Chuck E. Cheese has nothing you climb on, man. That's my real beef with it. And we've never talked
my
about
Chuck E.
my
Cheese
beef with
did.
Chuck E. Cheese, but it starts with there's not things you can climb on.
My beef with Chuck E. Cheese was, like, I didn't understand when it became Showbiz and when it went back to Chuck E. Cheese, because it was Showbiz Pizza.
Are you sure? This sounds like a Bernstein Bears type of situation.
It was Chuck E. Cheese forever, and then all of a sudden it was Showbiz Pizza, and it had the bear with the band.
They still got the bear with the band. The bear with the band stayed because they still got a bear band.
Sounds like you still go.
Yeah, I've been not recently. I get there and I'm like, man, there's nothing to climb on here, and I'm ready to burn the place to the ground.
Okay, real quickly before we wrap this segment, just to confirm, Allen Iverson, also known as the Answer.
He was the Answer. Yeah.
The Answer.
Why does that not sound familiar to me?
And one of the reasons he had it, when he showed up in Philadelphia, he only had one tattoo. It was a bulldog, and above the bulldog it said "The Question," and then he signed a deal with Reebok, and every style of shoe that came out after that was The Answer.
I don't remember that at all.
Hey, man, I know we had plans for this next segment, but I feel like this Chuck E. Cheese Showbiz Pizza thing is big.
I like it.
And,
I'm researching right now.
I am too. So, and it turns out Showbiz Pizza was separate.
Yeah.
They were separate, but then Chuck E. Cheese took it over. They took it over. Right?
They're animatronic.
So I don't know. I've never heard of Showbiz Pizza, just like you've never heard of Discovery Zone.
I see. Well, the Chuck E. Cheese in Raleigh became a Showbiz. Anyway.
All right. We got to take a short break. The Outlaw Lawyers, Josh Whitaker and Joe Hamer, managing partners, Whitaker and Hamer Law Firm, practicing attorneys here in North Carolina. Cassandra Nicholas, also an attorney at Whitaker and Hamer, joining us remotely from Morehead City. I'm Morgan Patrick, consumer advocate. We'll wrap it up right after this.